Welcome to What's New in California Privacy 2026. I'm Christina Tucson. I'm the chair of the Beverly Hills Bar Association Privacy and Cybersecurity Law Section. I'm delighted to introduce our speakers, Sarah Bruno and Lawrence Burns. Sarah Bruno is a partner at Reed Smith LLP's San Francisco office and a trusted advisor to companies in the entertainment, technology, beauty, consumer product, and healthcare industries on privacy, intellectual property, and advertising matters. She counsels clients on data privacy compliance, product launches, marketing strategies, and IP protection, helping them navigate complex and evolving legal frameworks across jurisdictions and media platforms. Sarah is widely recognized for her leadership in cyber law, privacy, and trademarks, and has been consistently ranked by the Legal 500 and Daily Journal. We also have Lawrence L.B. Burns, who's an associate with Reed Smith's Emerging Technology Group, where his multidisciplinary practice focuses on privacy, intellectual property, data innovation, and artificial intelligence. He advises clients on navigating complex U.S. risk mitigation strategies and supports advertising, marketing, and technology initiatives, while also bringing significant experience in privacy litigation, data breach initiatives, class actions, and IP disputes. LB regularly speaks on AI-related topics, including generative AI, AI-specific contracting, and open source data consideration. We're thrilled to have them joining this panel today, and let's get started. We will accept questions at the end. Feel free to put them in the chat as we go along, but there will be time for questions at the end. And I'll turn it over to our esteemed panelists.
Great, thank you, Christina. Hi, everyone. Sarah Bruno. I'm going to kick us off today. Thanks for joining. Thanks for sharing your lunchtime with us. As Christina mentioned, we're going to be talking about what's new in California privacy. LB, if you can move to the next slide. We have a brief agenda here. Yep. We're going to start with just a summary. We're going to look back for a minute just at what has happened on the enforcement side in 2025, because I think that'll set the stage for what we have in front of us in 2026. Then we're going to talk a little bit about the regs. That'll be more about, the actual paper that we're looking at in 2026 and what's coming. And then LB is going to talk a little bit about what we're seeing that's interesting and practical, a lot of the practical guidance we're giving right now. And then we have time for questions at the end. And also feel free to put some questions in the chat. And if we don't have time for questions, we will circle back with you by email after the conversation, certainly, and get back to you. And with that, we can move to the first section of this. Okay, so we're going to, like I said, we're going to start by talking about some of the cases. I don't know how familiar everyone here is with the California Consumer Privacy Act, but it's been around now for 5 years. The point of this conversation is to not give a summary of the CCPA. It's what's new with California privacy. So again, we're going to be talking as if there's a general awareness of California, the CCPA. And with that, we're talking about some cases that came out in the last couple of months of 2025. We have the California Privacy Protection Agency had a few interesting cases that we're highlighting at the end of 2025, and one was with Tractor Supply Company. I wanted to highlight that most of these cases have a very familiar theme, and if you listen to the agency and you go to some of the regulatory chats across the board, the regulators in all of the states that have these comprehensive privacy laws, there's now 19 of them, the regulators are pretty consistent in what they're looking for, and that's outward-facing compliance. Showing up on your website that you have systems that demonstrate that you're compliant with the law. And that is having those opt-outs if the law requires it. California is one of those states that has the strict requirements, the do not sell or share. And again, that's if you meet the thresholds for the CCPA compliance. And if you do, you have to have that do not sell or share link if you are selling or sharing data. And with that comes the opt-out. And a lot of the focus of the California enforcement is on these businesses that when they're The CPPA, the Privacy Protection Agency, is doing their checking. They're noticing that some of these companies don't have that outward facing compliance, and they've made it very clear that that's where they're starting. They're sending those check-in emails. They're seeing if you're responding to consumers' access requests. They're checking to see if you have your opt-outs correctly processing on the website. And if not, you're going to start to get those inquiries from the agency. So a lot of these cases, that's where it starts. And here with Tractor Supply Co., that's what we had. We had the actual end result is they determined that there was an ineffective opt-out. They also had an older privacy policy that didn't have the appropriate language for current CCPA compliance. So that was a need to be updated. You should, if you aren't already and you're working with your clients, you need to make sure they have regular updates. It used to be you could get away with every year, every 18 months, no longer. You should really have clients that are looking at their privacy policies every 6 months to make sure they're up to date, not only for California, but there's all these new laws that are coming out routinely, and you need to make sure your clients are routinely updating their privacy policy. With the Tractor Supply Co., it was an older policy, it wasn't up to date. They also weren't complying with the employee notices. That's important too. California is the one state where you have to have employee privacy notices. That they were behind with that as well. And then finally, data processing agreements. They didn't have that either. Again, we need to make sure that the transfer of data to third parties is covered with an agreement. That's something that's required now in California. And that was lacking as well. So that's a good one to start with because we had a lot of issues. Next, we'll move to Sling TV. This one really had the opt-out issue, and it was part of an enforcement sweep. And we'll get to this in a second, but one of the things that Bonta does and California does is they announce that we're doing an enforcement sweep. And one of the enforcement sweeps they announced was streaming TVs. Sling got wrapped up in this, which is part of the problem here was, again, the opt-out, but they also focused a little bit on the fact that it was complicated to opt out. It was more steps to opt out. It took longer for the consumers to have to go through that opt out than it did for consumers to opt in. So if you make it more complicated for consumers to do the thing that you don't want them to do, which is maybe opt out or remove their data or whatever it may be, that can be considered a dark pattern. And you could have again, the California Privacy Protection Agency is checking on this stuff, and suddenly you have an inquiry, and then they're going behind the curtain to see what else you have going on. So, and then the other issue here is they didn't have the opt-ins for teenagers. You need to make sure if you're selling personal information for targeted advertising that you have 13 to 16-year-olds opting in on your site, and they didn't have that. We can move to the next slide. Jam City was similar, a little bit similar to Sling. I mean, we had that opt-in issue. They didn't have the dark pattern issue, but again, it's important that you're looking to see what you're doing with teen data. You're figuring out if you have teens on your site, and if you are, you're selling or you have that targeted advertising, that you're making sure you have an opt-in. And then again, it was the opt-out. Otherwise, it was the opt-out for their other mobile games, and they weren't having that compliant. Again, these are just outward-facing things that the CPPA was checking on. This last one is a little different. You see how small that settlement was, $56,000. Not a big deal. I like to highlight this one, because it's a data broker. Again, this was another part of another sweep. I mean, the CPPA is focused on data brokers and making sure that there's this registration, and we'll talk about that for a minute in a few slides. But this was an advertising agency that didn't register as a data broker, and they found them to be a data broker. And one of the things they said is a sale is a sale, and what a data broker is they've defined this quite clearly. If you are a company that is selling the personal information, collecting and selling the personal information of a lot of consumers or to third parties, and you've collected it and you're selling it to third parties, and even if you've collected it from a cookie on the website, if the consumer's intention wasn't to have that data go to you, then that's considered a third-party collection, and you're selling it to a third party. That's considered a data broker. Basically, it's like an indirect collection of mass amounts of data, and you're selling it. So a lot of these advertising agencies are essentially doing that because they're collecting data on behalf of they're collecting data essentially as a third party and selling it to another party because the consumer is not intending that data to go to that party. They're intending the data to go to the first party, which is the company that they're buying the shoes from on the website. They're not intending it to go to the advertising agency or whatever party it is that's collecting that data and selling it to other parties. So that's a data broker, and that company has to be registering at the CPPA on the California Cal Privacy site as a data broker. And so this is an interesting one because 56,000. So a lot of people are like, do I really care? A lot of companies are like, well, I don't really care. I like to highlight this because it also requires them to, the other part of this was they need to have DPAs. So in a lot of situations, we have these advertising agencies that may not want a DPA. And this was also highlighted as part of this case. On the other hand, we have some that are saying, well, it's 56,000. And so it kind of goes back and forth because on the other cases, if you saw, they have really big penalties, and this one didn't, but they still highlighted this, and have this up on their site as one that they're going after as part of their data broker enforcement sweep that they've been doing more recently. Okay, we can move to the next slide. Again, these are just some of the sweeps. They did a sweep with employee data. They did a sweep with data brokers. That's the purple one. Geolocation was part of their sweep. I mentioned that they did, as part of that, they did automotive data collected from cars, part of the geolocation. And then that last one is just the streaming, to reference the streaming sweep that they did. We can go to the next slide. And now we're into 2026, and this was just recently, they announced an investigatory sweep into the hotel, retail, and grocery industries with surveillance pricing. And this is actually, I think, showing that the CPPA, well, this is BANTA, but California in general is getting a little bit more specific with what they're looking at, a little bit more in depth at what they're looking at. In that this is surveillance pricing, which is a layer below those outward-facing compliance measures. We're now doing a little more in-depth investigation. So surveillance pricing is essentially when you're you're collecting data, running it through an algorithm, and determining a price that a consumer may be willing to pay for something based on the location they're at. And in order to provide that pricing, the theory is that it involves personal information in addition to other information that may be relevant, which is just demographic information and other aggregated data that you've collected based on me being in San Francisco, for example, and what I'm willing to pay for an airfare ticket or whatever it may be, or a pair of shoes or whatever I'm shopping for, versus someone in Seattle shopping for the same thing. So Banta's note is that it may be a violation of the purpose standard of the CPPA, which is that you can only collect and use the data for the purpose for which the consumer expects you to be using it for, which is me buying a pair of shoes. And that's why you're using my data. You shouldn't be repurposing that data to determine what I would be willing to pay for an airfare ticket. And so the investigatory sweep is to check in with these companies to see if they're actually tagging and using the data in accordance with what the purpose the consumer believes that they're providing the data to the company for, and not some other purpose. So this is a good reminder. I like this one just because I think it's going to be really interesting to see where this lands and if anything comes out of it. And it also just shows that we're getting a little bit more in depth with what California is starting to look at. It's also showing the data minimization standard because it's going to hit on retention as well. You are supposed to be telling your clients to dispose of data after a certain amount of time. If you're using data to be trained on algorithms, you may not be disposing of it. So it hits on a lot of points that we are, as practitioners in this space, telling our clients. We can move to the next slide. This is just a hot list, what we are talking about in this space. And I've hit on a lot of it. Kids safety, we didn't talk about, but that's certainly, I mean, we talked about a little bit with the opt-outs, but that's certainly coming up a lot in our practice. Sensitive info is coming up a lot with making sure we're talking about that. AI is going to come up soon, and then also LB is going to talk about that in his section. And one I would add here is dark patterns. We mentioned that with the sling case, but that's something else that is coming up. We can move to the next slide. Okay, now this is the wordy part of the presentation. We're going to talk a little bit about the regs. I'm going to move quickly through this section somewhat because it's the regs and it can be a little bit more heavy-handed, but we want to make sure we have time for questions at the end and also the practical part of this, which is a little bit more fun to talk about. So there was some clarification in the regulations that came out. Some help, I think, that we got in the most recent final regs, which were announced in September of 25. One of them is that now, when you recognize GPC signals, global privacy control signals, on the site, so when someone actually has the global privacy signals deployed, you have to, as a site, make sure that you're making sure that you're letting them know that it's been honored. And this is just an example. They actually have an example in the regs that they've provided, or on the site they've provided, but you have to be making sure that you're doing this. One issue I've had with a few clients is just making sure it works properly. Everyone, and you saw that in the cases as well. I mean, checking on this routinely is really important. I mean, we're also busy. I mean, it shouldn't be what you as a lawyer are worried about, but unfortunately, do check to make sure that everything's functioning properly, because unfortunately, that's where it's not your problem, but it's not your fault, I should say, but that's where it becomes your problem when you think everything's up and running, but something's just not working properly. But this is now part of the regs that you have to show that it's been honored. This is a helpful clarification, is that a consumer closing or navigating away from a pop-up window on a website that requests consent without affirmatively selecting the equivalent of an I accept button shall not constitute consent. Such a method for obtaining consent is confusing. I've always thought that. I'm sure we all have. Like, if you just leave that cookie banner on and click on the page and suddenly it disappears, you haven't known what you were actually doing. That's no longer considered consent in California. So this is helpful for you to know if you have clients that are working or aiming to do business in California and have to comply with CCPA. That's not going to be considered consent. And then symmetry and choice is actually called out here. I mean, in the decisions that we've seen for CCPA, that's been stated that you have to, if you have a red accept, you have to have a red reject. It's symmetry and choice all around, but now it's actually included in the regs. Another little part of the regs that were helpful is if you're sharing data with service providers, you have to now include in the privacy policy the categories of service providers you're sharing with. We can move to the next slide. Here's the data broker section. I've already talked about this. You must, in 2026, you must not only register with Cal Privacy, but you also must comply with the drop, which is that you have to delete data within 45 days if someone has registered on Cal's site to have their data deleted from data brokers. And so that's been, I'm sure if you're practicing in this area, that's been heavily publicized. And I think we're going to see a lot of enforcement coming up soon after the requirement date from California as well. And it'd be interesting to see what the fines are coming from that. Like I said, that one fine was a little bit smaller. Moving forward. Okay, so this is a big part of the regs. Those were little things. This is the bigger section that everyone was talking about. Automated decision-making technology was finally flushed out. Everyone was waiting on this. We are one of the first here. We're the first to really have this heavily flushed out part of our privacy law. And here we have a business that's subject to the California Consumer Privacy Act that uses ADMT to make a significant decision concerning a consumer must comply with this. So what's a significant decision? That's the first thing we have to ask. And here's the list, and it's straight up within the act. So yay, this is helpful. Many of my clients at least find this to be helpful because they immediately think, well, we're not going to do this unless the employment space. And I know a lot of clients are using AI in the employment space, at least to try to screen applicants. So I do know it comes up here, and it certainly is helpful in that space in particular, given the number of applications, especially here up here in the tech space, and I know all over, but we have so many applications for certain, tech opportunities that it is a way to try to minimize those. So we can move to the next slide. And Albie, I think you were going to cover this one to give me a break.
Yeah, thank you, Sarah. So what is ADMT? ADMT has three and a half-ish elements: process personal information using computation or automation to replace human decision making or substantially replace human decision making. Replace human decision making is easy. If you're using ADMT, and if you're processing personal information in automated or with computated analysis in a way to make a significant decision, you're gonna have to provide an opt-out in a way that involves no human decision making whatsoever. But what does substantially replace human decision making really mean? If you have an automated process that processes personal information to make a significant decision, and the human is, has some type of general oversight or they're fact checking, is that enough human interaction to make it so this is no longer ADMT? We don't know. The regs are pretty new on this. California is, like Sarah mentioned, at the forefront of this. So if you're taking a conservative standpoint, I think unless ADMT is being used basically ancillary to like a lot of human interaction, you really want to lean on the side of being conservative and having those opt-outs if ADMT is anywhere near close to making decisions that could be considered significant under the CCPA. And we do have some clarity. So we don't know very much about what substantial replace human involvement is or human influence is, but we do know what ADMT is not. It's not what web hosting, domain registration, networking, caching, website loading, data storage, firewalls, antivirus, and all this good stuff. But the main one that it does include is profiling, and profiling is basically using ADMT to draw inferences about consumers in a way that's going to be able to, again, going back to the definition of significant decision making. So yeah, it'll be interesting to see if the California legislatures give us some more clarity about how much human involvement is going to be needed to kind of get us out of that ADMT framework. But for now, we're going to definitely be advising and leaning towards providing those opt-out mechanisms for ADMT.
Yeah, so the two things you should be looking at when you're advising is one, significant decision, if that's being made. And then two, if it is being made, how much human involvement, and looking at that substantially replace human involvement decision that we saw there. And then if you are checking those boxes, we move to the next slide, which is, why does it matter? Why does it matter? Because here we go to the next slide, which is you have to have an opt-in or opt-out. We move to the next slide, actually. You have to have an opt-out for the ADMT, and you have to have a pre-use notice. So you have to have a separate notice. It can be part of your longer privacy notice that explains how you're using ADMT and the process, what decision it's actually making for the consumer. And it has to be presented at or before the point of collection. So this is where it gets it can be a little bit much for an applicant, let's say. And again, if you're giving them the ability to opt out, it can be a little bit complicated, again, if you have an applicant. So that's where some of the clients that we're working with are, debating how they can do this, or if they can do it in the employment space, or if it's worth it. And we can move to the next slide, Elby. And so you also have to give access. The consumer may request a business provide information to the consumer about the business's use of the ADMT. So similar to what you have for general access rights for consumers being able to write to a company and ask to access their PI. Here you have the consumer can access why you're using ADMT. They can also appeal the decision that's made by the ADMT if they want. And again, these rights can be addressed in the privacy notice that you provide. Next slide. Okay, so the next big chunk, and this is, I think this is what I'm getting the most questions about right now is the risk assessment. And this is another part of the regulations, the risk assessment that has to be completed and provided to the CPPA. And here we have the why the risk assessment must be completed. And we have the phrase significant risk again, and significant risk to consumers' privacy. And then we have a list of what is a significant risk. Selling, sharing, or processing PI using ADMT. So here we have the reasons you selling, sharing to use ADMT to make a significant decision about a consumer. Using automated processing to infer. So the ones I like to highlight here. We have significant decision, which again was defined back a few slides ago. So those are employment, housing, credit decision, financial, I think credit decision, a few others, but we have that significant decision defined there. What I like to hide here, maybe because I do a lot of in the advertising space in particular, is the inferences that we have here, which is the using automated to consumers' ability, aptitude, performance at work, health, personal preferences, interests, reliability, predispositions, behavior. It's that fourth bullet point. So that one is pretty broad in a lot of ways. So we get a lot of questions with respect to that. And there in particular, we have to really think about how broad that's meant to be interpreted and whether, I mean, in most instances, we have clients that are doing risk assessments because of that one in particular. Also, we have clients that are just deciding to do them because it helps them sort through what it is that their business teams are doing, because a lot of times they may not have business teams that are 100%, they have an end result in mind that they're working through that frankly sounds more ominous from a privacy standpoint. So they start with they work through a risk assessment for that reason, and we'll get to why this could be problematic in a few slides. But that bullet point there is very broad, and so for that reason we have a lot of clients that are doing it. The last one obviously makes sense. Facial recognition, emotional recognition. I mean, that to me is high risk as it is, but we can move to the next slide. Here's the contents of a risk assessment. Probably most of you, if you're working with clients, have a risk assessment, especially if you have clients in the EU. A lot of the clients we're working with have been working off of their EU risk assessments just to modify for the US. But here's what we have. A lot of them, the clients that LB and I are working with, have just modified their current risk assessments to address ADMT. Some of the things we talked about in the ADMT portion of this, they're modifying their risk assessments to include levels to address that. Again, benefits and consequences of that is very important, because that's one of the main reasons you have a risk assessment, is to talk about the benefits of the use of the whatever the technology it is, or whatever you're developing. The whole purpose for the risk assessment, which again is when that business team comes to you with this end result they have in mind, when you ask them the benefit, this can help you, and it also can help them realize some of the risks, and then that can help you flush out, where this may land as far as the end result, which is that at the end of the day, we have to bring this to someone to sign and approve. Data retention, and like one of the issues is now we have to delete the data at some point as part of our retention schedule, and can we delete it? And if we can't delete it, we have to come up with some basis for that, and some retention, schedule and plan for that data, and how we're going to dispose of it and or track the use of that data for data minimization purposes. Okay, we can move to the next slide. So when we have some time for this, and again, this information is included so that we have it as we move forward. But we do have some time here. But the big thing is once this becomes a requirement every year on April 1st, you have to submit these risk assessments. And this is the next slide is, to me, one of the bigger issues, which is the who. The report must also include attestation signed by someone sufficiently knowledgeable and directly responsible, member of the business's executive management team, under penalty of perjury under the laws of the state of California. So back to the ominous reason your business team may have for the risk assessment. When they come to you with this idea, knowing that they have to have this plan signed or this risk assessment signed by someone on a member of the executive management team, they better have a really good idea, and we better be really weighing out those risks and benefits, because at the end of the day, someone with this level of authority has to sign this. And this is, again, something we're talking to clients about, because you really have to think through a lot of things with this part, which is making sure, do we want to have this document confidential and privileged? On the other hand, does this document have to go to Japan to be signed? Does it have to go to Turkey to be signed? So we really have to think through this part. And again, back to, do we want this risk assessment? Hello, do we want this risk assessment? So, this is a very important process, and it's one that you have to, as the inside counsel, you have to really, inside or outside counsel, you have to really make sure you're asking those initial questions as to why, the why, and making sure you're drilling down on all of that process as you move through the risk assessment.
It also creates an obligation for teams to kind of work closer together. A lot of the times with our clients, you see the business teams be separate from the engineering team that's actually, doing some of this more high risk data processing. So again, you want to make sure that when you're advising clients on this, that they know from the outset that eventually someone maybe a little bit higher than them is going to have to know about this and sign this.
Great, that's good, LB. Okay, we move to the next slide. All right, this is the last part of the regs that we're going to cover, and this is the one we're going to move most quickly because it's more technical in nature. We've given this in a very abbreviated fashion. I do suggest, if these are lawyers on the line, I do suggest you read this in tandem with someone on your IT. I mean, not this, the slides, the section of the regs in tandem with someone on your IT. It's not that you won't understand it. It actually is written for lawyers. You will understand it, but it would have been a lot of words on the slides about the nature of the technical and administrative safeguards. You need to make sure the boxes are checked. And it can be a list that can be, put together by your team. But it is the general list that we're used to seeing as lawyers for what is needed in a cybersecurity audit. I mean, of course, it's fleshed out in length, but at the end of the day, you're going to have to make sure your IT is reading that list against, mapping that list against the standards that are current right now, and making sure they are working with either a third party or someone internal that's not biased to create the audit. So we did not include all those words on these slides. And so that's my disclaimer for this. Is just a broad overview of what you should be thinking about with the audit outside of what those requirements are. Here's the requirements for actually the companies that need to get the audit. I had a few clients that were very happy when they saw this because they were like, that's not us. So here are the requirements, and then you can see it's bigger organizations and significant risk. And then you can see that, again, they have significant risk as part of it. And then they tell you what significant risk is. And if you earn 50% or more of your gross global revenue from selling or sharing PI, or it's a revenue threshold and a data threshold. So we can move to the next slide. So if you meet that, then you have to worry about the cybersecurity audit. I included this because I think it's good to know. It can either be an internal auditor, but if so, it has to be highest ranking auditor must report to a member of the business who is not responsible for the cybersecurity program. So there's a very specific requirement if it's an internal, but it could be someone external, obviously. In any event, it has to be someone impartial and independent from the business decisions. So we can go to the next slide. Here's what needs to be considered. These are clearly delineated. You have to, make everything available. And I like the middle one. No audit may rely solely on assertions or attestations made by the business management. Again, I think that's aimed obviously at the internal auditor, but good that they put that out there. And the auditor gets to determine the documents that are appropriate to review. You can't have, the business team telling the auditor what they should be reviewing. Move to the next slide. Here we just want to highlight some of the, these are some of the things that they should be considered. But frankly, like I said, you should take a look and review the actual sections of the regs with someone on your IT. Again, if you've been practicing in this area for a while, you're used to seeing the standard terms for technical and administrative security requirements that are in the regulations that need to be included. You can move to the next slide. The report has to say, essentially, there's why I included this is that it's very specific with what the report has to cover. And as the lawyer, you should know that it actually says that it must articulate the process, activities, and components of the program, what criteria are used, the evidence examined. So if you have an auditor preparing the report, you should be looking at the regulations and making sure that it matches what is required in the regs. Explain the why the processes, the activities, and the components were assumed. I've looked at reports done by third parties. A lot of times it doesn't really necessarily explain the why. So this may be a new level to these reports, is why these things were appropriate, why the evidence. Often it just tells you what, and of course the how things can be fixed by the auditor security, whatever the third party is. But the why is interesting. And so I do think that's a level that may not be included in some of these reports that has to be added. And then the effectiveness of the components in preventing PI loss. So what they're suggesting to you and what needs to be, what they found was working and wasn't working. So they also suggest that that has to be explained. Again, I thought that these were interesting because they actually went into the detail of what has to be included in the report. So I think this is good for the lawyers to know that there is a checklist or there's a list of what the CCPA regs say has to be included in the report. You can go to the next slide. And then the title of up to 3 qualified individuals responsible for the business's cybersecurity program. So those individuals have to be named. The auditor's name, affiliation, and qualifications have to be named. And then a statement from the highest ranking auditor that certifies they completed an independent review of the business's cybersecurity plan. So again, this is serious stuff. And we can move to the next slide. I think this is notable. If you had a data incident, a copy of any notifications that were sent to the affected consumers has to be included, and any notifications to an agency with jurisdiction over privacy laws in California have to be included. This is all, to me as lawyers, we just have to be aware that this is all going to be in that report. Move to the next slide, please. Good news is that if you have an audit that was prepared for another purpose but meets all of these requirements, you can use that. So I don't know if that will ever be the case, just given the nature of the scope of this. But if you do, that you can use that. You can move to the next slide. But the reason I said this is so dense and why it can be we should all be thinking about it is, yes, we have to submit it to the agency and have it with the certification that it was completed. And that, of course, is going to be, daunting for many companies. And with that, we can move to the next slide. So now we get to the more fun part of our discussion, which is going to be led by LB, which is more into, I think, what probably if all of us or any of us are practicing in the privacy space, we're all dealing with, which is the California Invasion of Privacy Act and the claims we're seeing, and also just some of the more interesting components of it, which is some of the practical guidance with respect to counseling in the area of AI.
Yeah, so the California Invasion of Privacy Act makes it unlawful to intercept or record confidential information without consent or aid third parties in doing so. And that is I think that was intentionally drafted broadly, and then we've since been trying to figure out what it means. So initially it was intended to govern telephone conversations, but not even recently, in the last maybe 5 to 10 years, there's been back and forth about what it actually governs. So last year, the California legislature added this language to the actual statute, saying the legislature hereby declares that advances in science and technology have led to the development of new devices and techniques for the purpose of eavesdropping upon private communications, that the invasion of privacy resulting from the continual and increasing use of such devices and techniques has created a serious threat to the free exercise of personal liberties and cannot be tolerated in free and civilized society. So what does that actually mean? That means that now, in addition to telephones, we have chatbots and virtual assistants that can replay software, tracking pixels and beacons, customer service call recording, mobile and cordless communication search bars. And the fun one, AI, is now being governed by CPPA because it's allowing the transfer of communications from party A and party B to a third party, party C. So under CPPA, you have the right to consent. The important distinction here is that California is an all-party consent state, which means that all parties of the communications have to consent to the communications, or the transferring the communications to a third party alleged eavesdropper could be a CPPA violation. That's different than a one-party consent state. So I'm gonna just kind of slow down and explain what that means. So the way we commonly see this is you have website owner, communicant or party A, consumer, that's party B, and then you have the third party that's providing the tracker, say Meta, Facebook, whatever. So under a one-party consent statute, if the website owner consents to the communications, it's usually going to be enough for the tracking of that communication to go to party C to not be considered an unlawful wiretap. California is not like that. You need the consent of everyone, including the consumer, for the communication to travel between party A and party B to over to party C, which is going to be the provider of the tracker, the cookie, the whatever. So how do you get consent? How do you get consent? I'm sorry. Consent can be explicit or implied, but these days we're definitely going to lean more towards explicit because these claims, as we're going to talk about a little bit later, are very prevalent throughout the U.S. and California in particular. So I'm sure we've all seen 1,000 of these. The way you get consent for trackers on a website is usually a cookie banner, and you want to have an accept all, reject all, and you want to, like Sarah talked about previously, you want it to have it be synchronized. So you don't want the accept all to be huge and in red and have the reject all be hidden in a weird different font. You want them to be parallel and symmetrical. And the other big one is under the new regs, clicking that X top right corner is no longer going to be considered consent. If you click that X, it's going to basically essentially be a reject all. So if you're a website owner, your clients are a website owner, you want to advise that certain cookies need to not be dropping until accept all is clicked, and clicking that X is not going to be valid consent under CPPA. So CPPA and digital wiretap claims are prevalent throughout the U.S. There's been 4,000 digital wiretapping claims in the U.S. since 2022. California is number one in number, because of course it is. But what's interesting is Florida and Illinois are number 2 and 3, and that makes sense because Florida and Illinois are both two-party consent statutes, so it makes sense that they're also seeing a bunch of CPA claims. Now, what we did want to flag for you guys is, although this number may seem high, depending on what kind of lawyer you are, if you're a privacy attorney, you're probably not very surprised, but this does not include pre-suit demands. And pre-suit demands, at least in our experience, tend to be the more numerous of these claims. We typically have a consumer or a plaintiff's counsel reach out to a website owner defendant, and they basically want to be paid to go away. And these often settle outside of court. So I think the owner of the tracker said that if these cases included the number of pre-suit demands, it would triple or maybe even quadruple. So that 4,000 is not the entire scope of these claims. They're very, very prevalent. And the other thing to note is the claims are almost always more expensive when cookies and trackers are dropping after a user clicks no. It's different than having no cookie banner at all. That's not good either. But you really want to make sure that if you have a cookie banner and your client is saying, hey, these cookies are no longer firing, and that is actually the case. Camp Listen, I might just call this Adidas because Camp Listen is hard for me to say. But anyway, on Monday, JD Super and National Law Review released a report flagging Adidas as a clear sign that CPA demands aimed at everyday digital tools and cookies such as pixels and analytic scripts are likely to pick up throughout the year. So plaintiffs sued Adidas over TikTok, Pixel, and Microsoft Bing trackers on website, alleged trackers and collected IP addresses, browser info, and PII without consent, claimed device fingerprinting violated CPA. Now, why is this a big deal? So we already talked about how CPA has expanded from being about phone conversations to being about all different types of technology, but we're now seeing a lower threshold for what confidential communications actually means. We're pretty square under California law that something like session replay, which is essentially a recording of everything that a consumer does on a website, was going to be considered communications under CPA. But now we're seeing that even things like clicks, IP addresses, browser info, that's enough to be considered communications under CPA and at least get a plaintiff or a claim if past the motion to dismiss stage. So again, if you have a tracker and it's only collecting, what we would consider to be very rudimentary, computer related data, device fingerprinting, even that's going to be enough to kind of give rise to these claims. So you really want to make sure that your cookie banner consent flow is kind of airtight. And again, I think Sarah and I saw at least 4 to 5 California rulings last year that kind of went the other way and said that this type of information, clicks, IP addresses, browser info wasn't going to be enough under CPA. We're now ping-ponging the other way. So we still don't really have a clear understanding of what this means, but confusion is good for plaintiff's counsel. So by all that we mean, you definitely want to make sure that your trackers are following your implemented cookie consent flows, and you don't want to be relying on arguments that you're not actually tracking proper communications. It's not going to be enough, at least not to get you to the point where you don't have to at least file something. And those motions to dismiss based on those arguments may fail based on this last Adidas ruling. What about AI? So like we mentioned at the outset, CPA is going to govern more than phone conversations. It's going to govern basically any technology that's being used to transfer communications from party A and party B to party C, which AI can obviously do. So Sarah and I have a client recently that wanted to roll out AI-empowered headphones that had a recording feature. And they were surprised to know that this kind of brought them under the CPA purview, because the headphones could take communication data and then transmit that data to a third-party LLM. So we're now talking about communication between party A and party B going over to party C. So I think we.
So yeah, I want to jump in on this quickly. Just to so everything you're saying, absolutely. Can you reset with the party A to party B to party C on this?
Yeah. So CPA governs the interception of communications without consent. So usually there's going to be consent between party A of the communication and party B of the communication. Party C tends to be the provider of the pixel, the provider of the tracking technology, aka a Meta pixel, a Facebook pixel, something like that. That's going to give rise to a CPA claim on a website. But you're also going to see rise to CPA claims with technology such as this that has the data that you're collecting going to, and what was in our case, Sarah, that third-party LLM, which brought these headphones under the purview of CPA. But again, we kind of have a better understanding of how you get consent on a website. But the question for me and Sarah was, how do we get consent when we're using headphones? So we we came up with a couple of different ideas, but the main one was we want to have an audible disclosure. Hey, your communication is now being recorded. You wanted to have some type of light, a prominent light that shows that recording is taking place. But you also wanted to have some other features that kind of toggle the recording off if the headphones picked up that there's now more parties to the communication that re-prompted the need to get this consent. We also tried to make it clear for the client because I think they wanted to use these headphones in Zoom, and we wanted to make it clear for the client that if Zoom got consent to recording, that wasn't enough consent for the headphones to be recording. Consent has to be based on each different recording flow. But we say all that to say that CPPA is going to be governing all different types of technology now. So the question you want to be asking yourselves or advising your clients on asking is whether or not communication is being recording is being done with full consent, especially in all party consent statutes. And if you're rolling out this type of technology in all party consent statutes like California, you want to have very conservative default settings. So you want to make sure that recording is not going to be taking place from the outset. You want to force the consumer to actually do things to make the recording take place. And then what else I want to say? I had one more thing. Okay, maybe it'll come back to me. Yeah, and then chatbots. Chatbots are another thing that are governed by CPPA. Why? Because chatbots tend to be, so they're on websites, obviously, but they tend to be powered by third parties. So again, if you have the consumer, party A speaking to website party B, if party C is the provider of the chatbot and party C is the one that's processing the communication prompt to ultimately generate a response, then that's now within the purview of CPPA because it could be an alleged wiretap. So you want to have your disclosures. You want to say, this chatbot is powered by XYZ. By using the chatbot, you consent to your communications being shared with XYZ if that is in fact the case. And there's also a couple other interesting laws that govern the use of chatbots. For example, in Utah, if a consumer asks if it's interacting with AI, you have to give a direct answer, like you are now interacting with AI or a human. Under California's bot disclosure law, it prohibits using bots to knowingly deceive consumers in commercial interactions. This is an interesting one. I think the context that came up for me and Sarah was if we have an AI chatbot or chatbot-like feature that gives product recommendations, say you're on website A and you're talking to the chatbot and the chatbot recommends a product from Amazon. If website A has a commercial relationship with Amazon, you want to disclose that because it could be considered knowingly deceitful if you don't. And then the FTC Act gives the FTC the broad powers to govern any unfair or deceptive practices in the marketplace. So again, you want to make sure that you're not using the chatbot in a way to get more PI, that you're not using in a chatbot in a way that deceives. And I think the context that this came up, believe it or not, was we had there was some company that was using a chatbot that pretended to be an attorney and didn't disclose that it was. Go ahead, sir.
Yeah, and I think one of the biggest points we have here is just the use of where we see this being a really big issue is the collection and use of sensitive personal information as well. And then also children's data. So it's just really important. We want to turn this back into the privacy conversation as well. I mean, with these chatbots, not only do we have what LB has highlighted here, which is the Utah and the bot disclosure, which is making sure you do have these. Again, if you're interacting, you have somebody saying if they ask, yes, I'm a bot. If they ask, and then also if you have a prompt about selling something, you make sure that there's a disclosure that you're interacting with a bot. But then you also have to consider the privacy issues if there's sensitive information or personal information that's being disclosed as part of these engagements, then you do have to think back to the privacy conversation that we had previously, which is making sure that you have considered all of the disclosures and opt-ins and opt-outs that we've already talked about previously, and whether there was the compliance processes in place for that, which I think that's what you're getting in here with the last bullet point, right, LB?
Mm-hmm.
Yeah.
Exactly. And then actually, let me go back because I remember what I wanted to say. For these, I know we're talking about a lot of required consent gathering protocol. And obviously, if you are advising companies that are rolling out AI technology like this, it's not really practical for them to ensure that every consumer follows that protocol. But what you want to do is have these mechanisms in place, and you want to be advising consumers to use them in the terms of use. And that way you can argue back against any allegations that you're aiding and abetting the recording of communications without consent.
It's good. Yeah.
Oh, and then lastly, this slide is just to show you that we're using the word chatbot and chat agent, but I don't want you to limit your mind to only what you see on a website. But the general idea of a chatbot, like we're seeing Alexa, we're seeing AI conversational cars, we're seeing AI conversational refrigerators. So anything where you're communicating with AI or your clients communicating with AI, you want to be advising them to at least be thinking about this and this kind of frame with these kind of risks. So that's it.
Yeah. And I think one of the issues that we're seeing with this, back to the sensitive and the PI collection, is where the disclosures are. And one of the things, with California in particular, especially with some of those cases we talked about, is you do have to have the disclosure. Most of these have an app, and an app that you download at the start. So there should be disclosures at the time of the app. And one of the questions we're getting from clients is, should there be another disclosure at the time you start to engage with the actual device? Because that's potentially another connection point between the consumer and the device that's outside of the app, and it could be a whole nother person. And so that's one of the questions we're getting. And unfortunately, the answer is not consistent across devices, to LB's point, because you have a headset that's different than possibly a headset that's connected to the app right in front of you, or whatever it may be. A screen while you're doing it, it's different from a stove, or something that you may have, an appliance in your house that may be entirely separate from a screen that you're connected to. So it does depend, I think, on the device and the level of connectivity as to the nature of what the disclosure is and when the PI is collected and how it's collected. But these are all questions that we're dealing with. And of course, as always, it's complicated with privacy, but it's similar to, I know, what a lot of the gaming companies are dealing with VR headsets and whatnot. So with that, we will wrap it. And I guess we have a few minutes for questions. Otherwise, I think we can say adieu.
We do have a couple questions from the chat, so I'll read those out if you all want to answer some of those.
Sure.
The first one is, can you express an opinion or view on banking practices wherein you call and they sometimes ask for your name and social security number and address and other PI on a recorded line? This appears problematic to me. One of the questions.
Yeah, I mean, that's so good question. And it's very state specific too. Since you're in California, I assume it's a California exchange. I agree that I agree that that's problematic. I don't know what bank you're calling, but I agree that that's problematic. To me, that's more sensitive information that's needed on a recorded line out the gate, but my bank doesn't do that, so.
Mine either.
Yeah, mine either. And like anything, right? I mean, there's disclosure issues and concerns about who's looking at that, right? After the
Yeah,
fact.
and just
But
to be
that's
clear, that's Graham Leach Bliley, which is has specific requirements for financial institutions and notice requirements. And so I don't know if you're given, like, there's requirements there in itself, and then you as a consumer, that's highly sensitive info. That's like that falls into sensitive info. And then the fact that it's recorded line to, what LB was talking about, the transfer of that. So yeah, I see a lot of issues. It's not to say they can't do it legally. Maybe they are, but there's a lot of compliance issues in order to do that they'd have to step through in order to do that. So.
right. We have another jurisdictional question. What are the points of attachment for CCPA to have jurisdiction over California companies delivering to a UK customer or a UK company delivering to California customers?
The points of attachment. So I guess you mean, like, when would the CCPA apply?
I think that's what it means, yeah.
Yeah, to a California company delivering to the UK. So there's thresholds for compliance with the CCPA, and you'd have to meet those thresholds for compliance. There's a revenue threshold, and then there's a data threshold. The revenue threshold, I believe, is currently
250,000. I think it's
Yeah.
250,000.
Yeah.
And then the
No,
consumer is 100.
yeah, the data threshold's 100,000 data sets, or you have 50, I think it's 50% of your revenue from selling personal information. And so you have to either meet one of those thresholds, and then you have to comply with the CCPA. And then if you do, yes, you comply with the CCPA, but once the data's in, if you're selling into the UK, then you'd also have to you'd have a touch point in the UK, so you'd have to comply with the GDPR as well. And then, yeah, they would make you comply with the GDPR to sell, I mean, the UK GDPR to transfer the data back to the US.
Great. Well, I think we are at time now, so I really want to thank our panelists for this really insightful presentation. Everybody should be getting the materials through a link as well as your MCLE certificate. So we, again, want to thank the panelists and for everybody who joined. Appreciate it.
Thanks, guys.
Look forward to seeing you at future events. In fact, we have another privacy event tomorrow that we'll be hosting that should be interesting as well. So thanks for joining, everyone.